Hello, YouTube. I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. You may notice a difference in the sound. I think we may finally have gotten rid of the clicky sound in our videos. It only cost us a combined $3,500. New computer, new cables, professional microphone setup, new microphone stand, external sound card input situation thing. Don't know what the problem was, but I think we got it licked. I think it's fixed, so that makes me happy. Um, let me know how the sound. Let me know how the sound is. Give me some feedback on the sound now, because I am not a sound engineer. We had a couple different folks on the channel. YouTube user John Doe, who has given us a ton of help. Viral Shedding Zombie helped us as well. There's been a lot of troubleshooting from fans of the channel, for which I am very grateful. Thank you so much. So give me some feedback on the sound. That would be great. We have a question here from YouTube user Michelle. I'm not going to read your last name because I don't want to associate this question with you, in case anyone Googles you or anything like that. Michelle asks us, I've been watching you for a while, almost a year. Wow. Thanks for watching. I hope it's helpful. Great info. You definitely helped me get answers. Oh, well, that makes me happy. However, I do have a few questions I cannot find in your videos. 1. Why would a company file a motion to strike only punitive damages? Also, can you explain what it means when a judge gives a tentative ruling? Can you create a video on tentative rulings? Okay, so let's deal with the tentative rulings part first, because that's going to be kind of quick. And then we're going to get into the motion to strike punitive damages. So, tentative rulings mean different things in different places, believe it or not. This is going to generally be a state court issue, although, listen, I've heard it in federal court before, and I'm going to share the context that I've heard it in my practice, and then I'm going to touch upon the fact that there's like a different use for tentative rulings in California under state law, which I am not allowed to give you an answer for, but I'm allowed to read you like a little blurb that says, I'm going to link this down below. The glossary of Thomson Reuters Practical Law says, tentative rulings are a term used in California state court litigation to refer to a preliminary ruling indicating the decision a judge is prepared to make on a motion or demurrer. Courts that issue tentative rulings usually do so the day before a hearing or the day of the hearing. A court may modify or reverse a tentative ruling at any time. For more information on tentative rulings, see California Rules of Court, Rule 3.1308, and the court's local rules. So that's the vibe in terms of if you're in California and dealing with a tentative ruling. Now, I don't know anything about that. I've never had to deal with that. When I get a tentative ruling, or when I use the phrase tentative ruling when I'm sitting as an arbitrator, what I mean is it's often in the context of people fighting about a piece of evidence, right? And a lot of times a judge or an arbitrator will say, listen, tentatively, I don't see why I would not allow that in. But I'll let you, if you want to brief papers on it, you're more than welcome to. I'll give you leave to make your let's go. Let's have a little motion practice on if that comes in or not, right? But tentatively, it's coming in. It's good evidence. Why wouldn't it come in? I'll just hear you out, right? Also, sometimes you'll get magistrate judges in federal court, or even court attorneys in different proceedings at different levels who would say things like, tentatively, I think some of these claims are going to get knocked out at summary judgment. So, obviously we still have to see the papers. It just based on our understanding right now, it just seems like tentatively, counsel, some of these claims are going to get dismissed. Or tentatively, counsel, you may want to talk settlement. I think some of these claims are going to trial, right? I've heard stuff like that. Is that really appropriate? No. I mean, obviously the context matters. I do, when court attorneys do it, especially in state court, court attorneys in state court will often be referees or whatever, act as a referee to try to get cases settled. And a lot of referees will just be very heavy-handed in trying to get cases settled. And that has value. It has value. But I do think that sometimes they overstep a skosh a little bit. Tentatively, I can tell you, a judge is going to dismiss this case. You can't. You can't tell me that. Because it's very unlikely the judge has read the case, because that's why you're here refereeing it. The judge hasn't worked on the case yet, right? You could recommend the judge might dismiss the case, right? Or you can recommend, like, it can go the other way too. Like, tentatively, I think this is going to trial. So, like, you might want to talk settlement here. You can't, just because I like that one doesn't mean you can do that one either. Because, like, listen, you're the court attorney. Obviously, you're going to inform your judge. The judge relies on you to a certain extent. But it's important to remember you are not the judge. She or he is the decider, not you. And although you might have the feeling that the judge is just going to do whatever you feel on a given case, you don't know that. So, and listen, attorneys are pretty capable of knowing that, right? Like, if a referee or a court attorney is like, listen, tentatively, I can tell you right now, like, this isn't going to come in at trial, so you better think settlement here. In my head, I'm like, you're not the decider. Thanks for letting me know what your recommendation to the judge will be. Gonna have to try to beat that. Or you know, I'm over here like, oh, that's a great decision for me, but it's not set in stone. So I still got to do full court defense to make sure the judge also decides that way. I just happen to have the court attorney or the referee on my side in this issue, right? So that's generally how I hear the word tentative in terms of a judge's finding. But I mean, if you're in California, I'll link that below for you. That's something I can't expound upon for you because I'm not allowed to speak as to the state laws of California, because I am not admitted to practice law in California. We would have local counsel for anything like that. Now, let's get to the first part of your question. Sure hope the sound is good on this video. Otherwise, I'm just wasting 15 minutes of my life. First part of your question is, why would a company file a motion to strike only punitive damages? Okay, so I don't know the context. Are they filing a motion to dismiss or a motion for summary judgment to knock out the claims you have for punitive damages in advance of, like, some kind of hearing? The reason they're filing that is because those are the claims they think they can knock out. They think they have a strong legal argument to get those claims dismissed, but they don't believe they can get the other claims dismissed. They believe if it's summary judgment, they likely believe there's a legitimate question of fact that has to go to trial, or the law is in your favor, or whatever it is. They don't think they can get it dismissed, right? Also, listen, there's always a heightened... The other side, the defense, wants to knock out the possibility of punitive damages. And that's true whether it's punitive damages under the federal laws or if you're dealing with punitive damages under state laws, which can often be different, which we're not talking about here. My conversation of punitive damages is tied purely to the punitive damages that flow from protected activity and retaliation claims in the realm of workplace discrimination, workplace sexual harassment, right? So check with local counsel if you're dealing with additional punitive damages setups, which do exist in several states in the U.S. Now, why are they so eager to make an expensive, time-consuming motion to knock out punitive damages? Because punitive damages are very uncertain. Like, punitive damages can be huge or they can be small, and the uncertainty of it all is very intimidating to everyone involved. And that goes doubly so for the side that might end up paying that. So if you think you have a viable legal argument, if you think there's merit to taking a real shot at getting retaliation claim kicked out or getting punitive damages off the table in terms of going to hearing, that's a huge value. Because, listen, you don't know what that number's going to be. It's very speculative because you're going to have a jury of people you've never met before decide the case, and if they decide it in your favor, they're going to be empowered to assign you some amount of punitive damages, the punies, right? And listen, they have a little more discretion when assigning you punitive damages than they do when assigning you economic damages, which are really well calculated. Like, we know what the economic damages are, and the emotional damages, which are subject to different limitations and caps and soft caps, and generally a little more known than the punitives, right? Punitives are not. Punitives, listen, the jury is specifically granted the discretion, and so the judge is less able and less willing, more importantly, to cut down a punitive damages verdict from a jury than she or he might be in the case of a too high or improperly calculated economic damages or emotional damages award, right? So there's every reason why you as a defense counsel would take a swipe at knocking out those punitive damages if you could, if you have a legitimate argument to do so in terms of the legal lay of the land, right? Michelle, I hope this helps. I wish you a great deal of luck, and I hope that you are successful. It sounds like things are going well. If I mean, listen, they're only trying to get one thing dismissed here, so maybe things are going pretty well. So I'll be cheering for you. I hope you get that big payday. Take care. If this was helpful, like, subscribe, comment down below, share the channel so it can grow. Also, comment down below my audio. Just tell me how my audio is, because the weird thing is, the audio artifacts I don't hear them on my computer. I have to go watch a video on like another device to hear them. I hear them on my cell phone. So like I know you guys are accurately reporting the clicking sound. I just, for whatever reason, my computer doesn't play the clicking sound when I play the videos back, which is just a huge time waster, because then sometimes you don't know the clicking was in the video until it like uploads and you're playing the video on YouTube. You're like, come on. All right. Thanks. Take care, everybody.